And how do we protect? What do we do when we die and we have a child with special needs? How do we protect them? How do we provide for them? So in the very basic of thing, when we say estate planning, we're not talking financial planning, where what you invest in and how do you retire and things like that. I'm referring to preparing the legal documents for upon your passing away or your disability. How do you take care of yourself and your family? So as most of us know, we hear of wills, and despite what people may think, if you have a will, there's a probate. A probate is a court-ordered procedure whereby the will is probated. It goes through a very, very specific series of events that takes in California now anywhere from a year to 18 months to do. It's very expensive. There are court costs, there's administrative fees. And if you don't have a will, you don't have a trust, the state of California is going to decide what happens to your assets. What they're going to do is they're going to say, believe it or not, most people think, well, you're married, you've got kids. The house was just in one of their names, one of the spouse's name. That spouse dies. Everybody's going to think right away that the house goes to the other spouse. Believe it or not, that's not correct. It actually gets split with any living children. So when we look at that and we look at problems that come about, we want to prepare for it. How do we prepare for it? Well, we do a trust. A trust, think of a trust as like a corporation. It's a legal entity that lives forever. It doesn't die. It can own things. Like a corporation can own a building, it can own a house, it can own lots of things. And a trust outlives us. It survives us. So upon your passing, that trust gives instructions on what happens with our assets. And because it requires no court intervention whatsoever, you pick what's called a trustee. A trustee is a manager. They're the person responsible for following the instructions of that trust. Everything when I talk about trust also applies to special needs trusts. And we'll get into that very, very quickly. I'm kind of racing through this part because it's not our core event here. So when we talk about trust, what we want to do is we want to avoid court intervention. We want to avoid lots of charges. So the trust, when you pass away, your successor trustee, because during your lifetimes, you are the trustee, you are the manager of that trust. And again, this is the same thing goes for a special needs trust. You are the manager, you are the trustee. Upon your passing, you name a successor trustee. That successor trustee takes over, and they're what's known as a fiduciary. They have a responsibility under the law to follow your instructions within that trust. Now, all of a sudden, there's an elephant on the screen. It's like a circus elephant. So despite that, when we have that trust and you pass away, The trust gives instructions on what it's going to occur. So, for example, if you say, upon my death, sell my house, split all the money with my 3 kids, that's what's going to happen. And that trustee you select will be responsible for making that happen. So that's the core basics of a trust. But now let's get into a special needs trust. Now, I prefer to call a special needs trust a supplemental needs trust. And why do I call it that? Because under the law, and this is Social Security we're dealing with, all that a special needs trust can do, or a supplemental trust, I'll use the names interchangeably. You can supplement the needs of a child with special needs. And why do you do this? You do this to protect the government benefits that they're receiving. When your child is receiving government benefits, as you know, they're limited to $2,000 in total assets, with the exception of some exempt things. Also, if they earn money, the government can reduce those government benefits for a dollar-for-dollar basis. So if they're getting 1,000, 700, 600, I know it's not much. The government will reduce that further. I'll give you, for instance, I had a client who would take their child out for dinner. You know, either take them out or they would come to their house for dinner, 4 or 5 times a week. It's normal. Child comes to your home and eats. This was an adult child who was living in a facility, but they would have the child come to their home. The government, in their annual review, the parents disclosed it. The government actually reduced the benefits paid because they said, no, you're providing something that the government pays. That's what that money's supposed to be for. So they actually reduced the benefits. That's how picky the government gets. So what do we do with special needs trusts for? We do it to provide for monies that your child will need after you're gone. Because let's face it, during your lifetime, you're going to just buy them what they need. But this is really after you're gone. It's a method for you to provide monies for the benefit of your child. It could also be a grandchild as well. And most importantly, the special needs trusts, monies, are not deemed to be that of your child. So they don't interfere with that $2,000 maximum. Now, when we deal with special needs trusts, supplemental needs trusts, there's no exact laws that dictate how we do this. It's done under what's called POMS. That's the Social Security Operating Manual. Social Security and most large government agencies like the IRS have operating manuals. These are manuals which the public can rely on in how things work. So this manual says that A, the trust must be irrevocable. Now, what do I mean by irrevocable? just that. Once you set this trust up, you can only change just a few items. And the only way you can terminate this trust is by having all the monies go to the beneficiary. All right, so it's can be very serious when you terminate a special needs trust prematurely, or it also terminates upon the death of the beneficiary. The beneficiary is the person who is benefiting from the special needs trust. Now, let's get into some terms that we use when dealing with yes,
so if you can, yes, I do. I'd like to know whether there's a date that you can say the trusts will expire, or
no, it expires upon the death of the beneficiary.
On such date, or will not be only on the death of the beneficiary. Okay,
correct,
thank you.
Correct. Unless what I have learned from my doing literally hundreds of these over the many years is that I put in certain language into the trust that it's basically an out clause. Let's say, for example, that your child is very high functioning and they get to the point where, you know what, they don't need this anymore. They're able to hold a job. They're able to get on with their life, as it were. Now, I realize when dealing with Down syndrome, that's not likely to occur. But, you know, we can have children who are very high functioning in Down syndrome. Well, I put clauses in the trust that allow at the discretion of the trustee to terminate the trust if the trustee feels it's in the best interest of the beneficiary, despite the fact that the beneficiary may very well lose benefits. Okay, it's an out clause. I also allow it where the other things that I permit, since we're getting to that area, I allow the original creators of the trust, which would be you folks, to change who gets the money after the beneficiary passes away and who are those successor trustees, because the names change. But getting specifically back to your question, did I answer that for you?
Yes. It expires or terminates at the death of the
yes, at the death of the beneficiary or at the canceling of the trust. But if we cancel the trust, that money must go to the beneficiary. You can't take it back.
Right. And when the beneficiary dies, we say, okay, the money goes to.
Well, you're freezing up on my end, so I think you asked what happens to the money. The money will go upon the death of the beneficiary to whomever you pick.
To be a special needs trust or not anymore because it's not.
No, it would not be a special needs trust. The trustee would literally write a check to whomever that's what we call a successor beneficiary. And they would get the money check to do what they want. The money would be what we call free from trust.
Thank you.
All right, thank you. So getting back to the trust. So let's get some terms out of the way when dealing with the trust. Again, this applies to any trust. There's terms that we use interchangeably. Trustor, settlor, grantor. They all simply mean the creator of the trust. When I write a trust, I call it the settlor, because there's no such thing as a settlor, settloree. You may hear of trustor, trustee, grantor, grantee. That stuff gets confusing. It drives the law students nuts. So that's why I tend not to use it when just writing a normal trust. So a settlor is the creator of the trust. The trustee is the manager of a trust. The beneficiary benefits from the trust. The successor trustee is just that. They are the manager in waiting if who you select to be the initial trustee, likely would be yourselves, die or become incapacitated. All right. Once.
Can I ask, how
Certainly.
many can you have, how many successors can you have?
I always prefer to have at least 3. You can have 10 or 15, though. The more you have, the better it is. And the reason why I like to have as many as possible, because it keeps you from having to make changes in the future if something should happen to those successor trustees. I mean, the goal is if a trust is written correctly, you shouldn't have to mess with it unless something major happens in your life. So ideally, I like at least 3, and I say 3 in succession. Now, you can have a group, a husband and wife, be a trustee, and they would, be at a level by themselves. And then you could have successor group number 2, successor group number 3. And you could have 1, 2, 3, a dozen people in that same group to be trustees at once. I never liked that. The only time I like more than a single trustee being in charge is if it's a husband and wife for their children. I don't even like the idea of 2 siblings being put in charge. Let's say, for example, you have 3 children. So one of your child has special needs, the other 2 you make as the successor trustees jointly. Well, what happens if they don't agree on a decision? Then nothing happens. I've had to go so far as to they had to flip a coin in front of a neutral third party. So I like picking an individual person, one person, to be that successor. All right. So let's talk about what that trust can do and what it can't do. It cannot, technically, it cannot supplant or replace any of the same services the government money is paying for. So when you receive a check from the government, that's supposed to pay for food, clothing, shelter. As we all know, what you get is a joke. You couldn't even rent a room for that. But there's ways around it. There's ways to do things, which I'll be happy to tell people in person when we're not recording. Not that they're illegal. They're just creative. How's that? So when we have our special needs trust, what can it be used for? Well, let's say, for example, your child needs a cell phone. They need to pay for medical devices not covered by Medi-Cal or Medicare. They need transportation, vacations, somebody to help clean their home. You can use it, and that's why I like the term supplemental needs trust, because it supplements their needs. Now, why can't you just hand your child cash? You can. We all know it gets done. But if that is reported to Social Security in the annual review, they can reduce or withdraw benefits. Also, remember, we've got a $2,000 total maximum amount of cash assets the child can have. Child, adult. So what do? How do you use the trust? When do you use it? Because this trust is irrevocable. Remember, I said, once that money goes in there, it can only go to your child's benefit until after your child passes away. So we don't want to turn around and put 100,000 or 200,000 into the trust right away. Can you do it? Of course you can. But the problem is, you don't have to. It's not a problem. It's just good planning, good thinking. Generally, what I tell people to do is, if you have a trust already, your own family trust, you let your family trust talk to the special needs trust. When I say talk to, your family trust, what happens when you and your wife are both gone, or if you're by yourself, how is your money get divvied up? If you've got more than one child, you can say, okay, I'm going to give my other children whatever percentage, and then you're going to leave the percentage for the child with special needs to their special needs trust. So you literally create the special needs trust, and you do it immediately. Okay, you create it ahead of time. That's the whole point. You want to create it during your lifetime. And then upon your passing, whatever percentage you have elected to go into your child's special needs trust, that's when it gets funded. We call it funded. Okay? Now, if anybody's a lawyer out there, a trust needs to be funded in order to be a valid trust. There needs to have property in the trust. So when I set up a trust, we just say the trust is set up with $10, and I tell you, take $10 out of your wallet, stick it in the drawer. That's property of the trust. You know I have a legal trust because it owns property. In order for a trust to be valid, there has to be a creator, a valid trust purpose, a beneficiary, and there must be property in the trust, money, or whatever. It could be a house, could be anything. So I often get asked, do I leave everything to my child? How much should I leave? That's entirely up to you. It's not a legal question. It's a practical question. Yes, sir.
Sorry, I don't mean to interrupt. Just a quick question, though.
Certainly.
So The special needs trust is funded upon your death, stipulated in a family trust. Is that correct? The family trust
Correct. Your
talks
family
to-
trust, yeah,
talks to the special needs. So normally, and I think in a family trust, it's funded during your lifetime. Is that correct?
yes, you
And then-
fund your trust during your lifetime. However,
Right.
you may have bank accounts that are separate,
Mhm.
and those should be the payable on death would be your trust.
Right. So then
So-
the special needs trust is funded upon your death, which is different from a traditional trust.
Correct,
Okay.
correct. And the reason why you do that again is because it's irrevocable.
Mhm.
Why do you want to tie up money when you may
Mhm.
need it yourself?
Yeah.
I mean, listen, if you're in a very good financial place and based on the numbers and size of the numbers that it's not an issue, then fund it now. But
You're right. It does make sense to do it upon death. It's not needed until then. So
exactly. So why stick it in there and lose control over it? I don't like that idea. I just don't like it. And depending on your age and health, I mean, and again, I don't sell insurance. I'm not pitching any products. None of that. I don't care how you fund it, but a good way to fund it is life insurance. It's a cheap way to fund it. If you have a whole life plan or term life or whatever, you can fund it that way. But, if you're, older or maybe have a physique like me, it's tough getting insurance. So that's maybe not an option or not a practical option. But like I tell people, I said, nowadays, I mean, with prices, we all know prices are going through the roof on everything. We don't know likely how much money we're going to have upon our passing. You may need some of that money. You may be in assisted living yourself. And I can certainly tell you, having a mother in assisted living for 6 years, it's expensive. It is very expensive. Therefore, I always tell people, unless you are 100% sure you're not going to need the money, fund it through your trust. All right? Does that answer your question? Okay. All right. So we look at going on to what happens when we die. So when we die, that trustee you've nominated, that successor trustee takes over. And in order for them to get control of assets, let's say you have bank accounts or whatever, and again, this applies to a regular trust as well as the special needs trust. All they need to do is show death certificate, and then the bank, and they need to show identification. The bank will already have a copy of the trust if you're setting up bank accounts in the name of the trust or something like that. And then that trustee will immediately have control of the assets. No attorney is needed. No court is needed. And that's the beauty of it. Can an attorney help you answer questions and do things? Yes, of course they can. But it's really not needed. And that's the big benefit of trusts in general. The special needs trust, that's the one that's taking care of our children. Now, I have done so many of these that I actually wrote a guidebook for trustees. All right. If you send me your if you send an email to law, LAW, at 3yl.com, that's law, the @sign, the number 3, Y as in yellow, L as in Larry.com. I, within the next 48 hours, will send you my trustee guide booklet that I wrote. Okay? It is written for parents, but trustees, and it really gives you the do's and don'ts.
Jonathan, can you put that in the chat?
Oh, okay. Yeah, I can. I just, let me see here. Oh, okay. I sure can. Just give me 1 second. I don't have it on this computer. That's my problem. Hold on a second. Give me 1 second, folks. If we want to take a 5-minute break, we can while I get this for you, because I think it's nice for you folks to have. I apologize for not having it in front of me.
I'll add it to the chat. I have it.
Oh, you do
Oh,
have
right
it?
here. Yeah, there you go.
Sandra, you have my book?
No, the email. The email.
Oh, yeah. Okay.
That way.
Um,
I'll just.
Okay, perfect. All right, you know what I'll do
Thank you. Thank you.
at the end? What I will do is I will upload it to the chat. Actually, that may be more complicated. But just send me an email and I will okay. I will just email it to you. So with that'll make life easier for you. It goes over in detail a lot of what I'm discussing today, but it gives you the do's and don'ts of what you can do and what you can't do. Let me give you, for instance, you remember what I said that you cannot provide funds for your child with special needs who's getting government benefits. You cannot supplant the government benefits. So for example, the money that they're getting is supposed to help pay for their place to live. Well, and I have a lot of clients say, listen, I want to rent my child an apartment. They're an adult, they're higher functioning. I want to rent them an apartment, but you can't do that because the government's going to say, well, you need to charge them rent. Well, you can't charge them $300 for an apartment that's valued at $2,500 a month. But what you can do is rent them a room. You can rent them a room in that apartment. So you're a terrible business person. You don't rent the rest of it out. Perfectly legal. As long as you have a regular lease and everything's done very, very formal. That's a method for doing it. That's just one example of the creative ways that we're able to accommodate our child without losing government benefits. Now, during your annual talk with the government, they're going to ask, does your child have any trust? The answer is no. This trust does not belong to your child. Don't confuse it with the trust that they're named as a beneficiary. Another trust, like if you had your family trust and you named your child as a beneficiary, that would need to be disclosed to the government. Because what the government would want is when they would receive the money from your family trust is what's called a 5-year clawback. The government is entitled to take back whatever they've received in government benefits for the previous 5 years. And if there's money left over that's above $2,000, there goes the government benefits. So what we want to do is we want to make certain that we don't violate the government benefits. And the key thing with the special needs trust is that money is never deemed to be your child's. They have no control over it. They have no say over it. It is not theirs. They only get it by way of things being purchased for their benefit. In other words, you can't turn around and give your child $50, technically. Because therefore it would need to be reported and the government could reduce them by an amount of money. There may be exemptions for some birthday gifts and so forth, you know, a one-time gift of $50, nobody's going to go crazy over. But on a regular basis, you can't do it. But again, what do you do? What do you use that money for? Well, that money is going to be used for to supplement their needs. Now, how does the special, your successor trustee, that's the person who's going to be the manager of the trust after you pass away, how do they know what they can do and they can't do? Well, that's why I wrote that guidebook. And it's just that, it's a guidebook for trustees. And it tells you what you can do, what you can't do. And that is less about for you as the parents. That was really written for that successor trustee. Because again, during your lifetime, there's no reason to fund the trust now.
Jonathan, there's a question. Gail's waiting.
Yes. Oh, I'm sorry, I didn't see. Please ask away.
Okay, I'm a little bit confused. My son is 58, Down syndrome. He
Okay,
does not handle money at all,
okay,
period. That's numbers and money. Or
okay,
I am his conservator now. He has
Okay.
2 siblings that are going to be conservators when I cannot. What would the difference be in setting up a special needs trust and just having the SIBs be his conservator? I believe I can get his Social Security sent to one of the SIBs and they take care of everything.
When you have a conservatorship, you've already gotten court. You really don't need it. I mean, it would almost be redundant. Okay. And if I can give you a suggestion,
Mhm.
during your life, have your children appointed as co-conservators,
They are.
but have them put on standby. I've
They
done
are.
it before. Okay. So have they been appointed by the court already?
Yes,
So all 3 of you are listed as conservators.
yes.
Good move. Excellent, excellent, excellent. So you're in good shape. You're in good shape. For those of you who don't know what she's speaking about, a conservator is where the court appoints another person to oversee the needs of an adult. This is what's called a conservatorship of the person. And that's where you make personal decisions for this adult: medical care, sexual activity, voting, and of the estate. That's where you deal with the person's money. And at that point, they could do that. But what this would also do, well, see, since they have full control over all assets, then they would be able to use money of your child's, you know. Now, is your child getting government benefits?
Social Security only.
Okay, so that's it. So, and that's your Social Security?
No,
From
his.
Okay, yeah, so, and he's got no minimums earnings or anything required.
He has no money at all.
Yeah, so it would really be moot. There are ways to do it if you plan on, upon your death, having extra money being left to him. If that's the case, then you would want a special needs trust. Okay, if there is no extra money to leave for his benefit, then obviously you don't need one.
Okay,
That would be the only reason why you would do it, is there's additional money that upon your passing, you plan to leave for his benefit.
the only thing that puzzles me is if his rent goes up or anything else financial, brother and sister would have to talk about it and pitch in and do it.
Yeah, I mean,
runs out of money.
if there's no, if the money's not there, it's not there.
Mhm.
You know,
And I have
Uh,
not
you
talked
know.
to Social Security because nobody's dead or anything. But as far as turning over his Social Security from my bank account to brother's bank account.
that's easy. That's an
Yes.
easy, it's
Okay.
just filing of a form. And with them being appointed joint conservators, it's not a problem.
Okay, thank you.
My pleasure.
I have a question. Are you,
Yes,
did I hear you say you don't need a special needs trust if you're the conservator of your special
No,
needs child?
only if you don't have extra money to give. So if there's no extra money to give upon your passing, then there's no need for a special needs trust.
Okay,
But if there's additional funds to give, then absolutely you want a special needs trust.
okay, okay,
It's the same thing, it's just the conservator, you may want to name the conservator or not name the conservator. Depends if it's a public conservator or not.
okay, okay.
Yeah. So,
Jonathan, can I
Yes.
ask you another question? So,
sure,
because if you have your typical children, and let's say you have a house and you have money, I don't know, you wouldn't leave money to your child with disabilities in that respect?
no,
Is that
that's
what
where
you're
the
saying?
special needs comes in.
Okay.
Yeah, you're gonna leave it by way of the special needs trust. Now, let's say, for example, you have a child, you've been very fortunate. So you've done very well for yourself, and your child is not receiving government benefits. You're providing all the funds yourself. You do not need a special needs trust. You would need what's called a spendthrift trust. So it's another kind of trust. It just doesn't have all the restrictions on how the money gets used like a special needs trust would. So there is a way to provide a special trust for that loved one if you're not receiving government benefits and you have plenty of assets. All right. So, and again, the only difference is it doesn't have the limitations on how the money gets used. Now, I'm surprised I haven't gotten any questions on the ABLE Act. Does anybody want me to talk about the ABLE Act? Yes? Oh, maybe? I'm seeing some
We're
shaking
all
heads.
muted.
Okay,
We're all muted.
okay.
What is the ABLE Act?
okay.
Never heard of it.
The ABLE Act is basically like a bank account for somebody who's disabled. They need to either be receiving SSI or SSDI. They need to be, the money gets limited to, it's a bank account. That's first off, it's a bank account. And it's money that could be used for the benefit of your child. It's got some very strict limitations. One, most you can put in there per year is 15,000. The maximum balance in the account is 100,000. The money can be used for education, housing, transportation, employment training, health services, financial, things of that nature. Now, when your child passes away, unfortunately, the money goes to the state. All right, so if you have a very small amount of money, And $100,000 nowadays isn't a lot. As we all know, money goes by very quickly. If that's the most you have, then maybe that may be a good idea for you. All right, that may serve a purpose for you. All right,
So question.
but that's
for you.
all it is. Yes, I'm sorry.
Yes, sorry. So so I guess like the main benefit of a special needs trust over like an Able Act bank account is that the money can be then transferred to whoever your other extraneous beneficiaries are. So like it can stay in your family and not just go back to the government when.
Exactly, and it's not limited to any amount. And
Gotcha.
quite honestly, $100,000 is nothing nowadays. You know, that can go by very quickly. You know, you pass away, and depending on the age of your child, I mean, they could be around, God willing, you know, 20, 30, 40 years after you're gone. $100,000 is not going to last long. You know, let's say they're living in a place upon your passing. You have a house, you sell your house, you know, assuming it's paid off, that's 800, a million, $1.5 million, you know. That can go into the special needs trust. You know, your trust can have instructions that say, hey, upon my death, let's assume you have no other kids, so you're not leaving anybody else money.
I also
You would
have another.
say,
Oh,
okay, let me finish this point, then I'll get back to you. So you just simply say, upon my death, sell my house, put the proceeds into the special needs trust, and you know, we would name the trust and everything else. Yes, your other question.
yeah. So what if like you don't have any other like children or like kind of like reliable trustees where you're not really sure like, okay, will they end up taking care of the person with disabilities or were they like try to pocket the money somehow? Is there some sort of stipulation in the trust?
Well,
that they spend
there's a
it?
couple of things you can do. One,
Okay.
let's say you're concerned about who you name as trustee. You can require a bond. A bond is what's known as a surety bond. That means if that trustee were to steal the money, then the bond company would have to pay it back. But depending on the functional level of your child, who's going to be looking at that, we could build in that, you know, an accountant, an independent accountant, you know, from a big accounting firm must do a review of it every year. There's ways to protect it, but it all depends upon how much money you're talking about. There are services out there, they're known as public-private fiduciaries, where we name this fiduciary to take over upon your passing, because some people just don't have people, especially that will outlive them. So we name this entity to take over. Also, in the event of passes away and there are no trustees appointed, you can have the court appoint a trustee. We could say we want a court of competent jurisdiction to name the trustee. The only problem with that is that's going to be generally a lawyer or professional fiduciary, and a court appointed things that would require an accounting every year or every 2 years. And all of that costs money. So there's a lot of extra charges that the trust is going to pay out, probably anywhere from 10 to 15,000, maybe more per year in costs that you wouldn't have if a friend is doing it. You know, and like I tell people, if you have a friend doing it, think about giving them some compensation. If it's siblings, no. You know, my personal thing is they should be doing it because it's family. But if you're asking a friend to do this, it's responsibility. Make sure, for heaven's sakes, you speak to the person you want to name as a successor trustee. Don't just say, hey, my friend Gary is my best friend. Truly, my best friend is Gary. And I know he'll do it. I know he'll be my beneficiary. Well, the problem with that is maybe they won't. It's a lot of responsibility. Maybe they don't want to do it. You know, so you need to think about and talk to the person you want to name as successor trustee. And, you know, you can name how much they get. You can give them a monthly amount. You can give them an annual amount. You can give them a token amount. Think about who you are naming. Are they good with money? You know? They, of course, are free to see an accountant, an attorney, and have those fees be paid for from the trust to assist them, a financial person. You know, again, it all depends how much we're dealing with. Now, I promised I would end by 11 o'clock. Please let me know if you have any last minute questions.
Yes, I had a question. First of all, thank you so much. This is a wonderful presentation.
My pleasure.
I was curious, so would you be at all willing to maybe send it to Sandra and maybe Sandra can send it out to the participants, or would you prefer?
Sure. Either way, 6 one half dozen the other, whatever you'd like. Listen,
Okay.
I'm not pitching you guys, okay? You know, if you want to get a hold of me, there's my email address. My phone number for the office is 818-347-5800. Or you just, you know, punch my name in, Jonathan Leventhal lawyer, and, you know, I'll pop up. You know, I charge $9.95 if you mention Down syndrome organization. Otherwise, I charge $14.95. Right, that's what I charge to the trust. But again, I don't care if you see me, you don't see me, whatever. If you do plan on getting this trust done, please, please, please make sure you see an attorney who regularly writes special needs trusts. And here's a question to ask that attorney. Ask them, does a D, the letter D, the number 4, the letter A, ask them, in a D4A trust, when my child dies, do I keep the money? Yes or no? The answer is no. In a D4A trust, the government takes the money. That's if there's a government, let's say they won a lawsuit and they get receiving money, the court will order it to go into a D4A trust. That's the code section, D4A of the code, of the California Probate Code. And that says, just like on the ABLE Act, upon your child passing, the money goes back to the state. So if they don't know the answer to that, or they don't know what a D4A trust is, use somebody else. Never, whoever you use for estate planning, if they ever want to name themselves as a successor trustee, get up and run like hell. All right? Because they're setting themselves up to make a lot of money in the future. It's very unethical. Is it legal? Yes, but it's extremely unethical in my opinion. All right? So,
I put Jonathan's information in the chat. So.
okay, I didn't even talk about that. Actually, the Law Fighter is it's Valley Estate Planning is the website. If you put my name in, it'll come up, Valley Estate Planning. Law Fighter is an old website that I think is still on my email. I've been too lazy to remove it. Oops. I thought I changed it. Oh. So that's really it, folks. All right. What I'll do, Sandra, is I will email you that document. All right.
Okay.
And I'll get that to you and you can distribute it you know, don't worry, people, you're not going to be emailed by me. I'm not going to be sending out a spam list or anything like that. If you come to me, great. All I want to do is make sure you go to a competent attorney who is used to writing these.
Jonathan,
Because if it's not done correctly, it's a problem.
Jonathan, how much does it cost to do a conservatorship?
A conservatorship runs about around $5,000, and there's over about 1,500 to 1,700 expenses. It's a lot of work, conservatorships. They're a royal pain in the neck, to be honest with you.
But that's the only way to be able to make medical decisions for your child, right?
That's correct. That's correct. The only other way is if they were ever competent and they signed a healthcare directive in your favor.
Okay.
And then they can revoke that
Okay.
unless they later become incompetent. So yeah, unfortunately, once your child becomes an adult, they get to make their own decisions. In fact, technically, the doctors aren't even supposed to show you their medical records any longer or talk to you about their medical condition. Most doctors, if you've got a child with severe disabilities, most doctors will, but technically they're not supposed to.
Right.
The
Yeah,
doctor can technically get into a lot of trouble, but there's nobody to,
right.
Rick has a question.
Any
I have
other
a quick-
questions?
Yeah, quick question, Jonathan.
Yes.
So if your child is extremely low functioning or even nonverbal, and they reach adulthood and they're still that way, the only way you can appoint somebody to care for their medical decisions is either conservatorship or
Because
someone has to deem that they're mentally aware that they're signing away a medical directive, appointing somebody as their.
Exactly. And, if they're nonverbal, non-communicative, it's not going to
Yeah.
fly. You're going to need a
Yeah.
conservatorship.
Right.
I've actually done conservatorships where I had a woman, similar situation, was had a conservatorship for her child for many, many years. But now she's getting older. The child was in a severe car accident. And wasn't a car accident, somebody else had a medical malpractice. Went in for a simple operation, things went bad, she came out a vegetable. Very,
Oh,
very
boy.
sad case. So she got a big award to care for her life. Her mother is her conservator. Her mother lost her husband years ago by herself. She has two very close friends that have been friends with her daughters, lived with her for many, many years. We actually got them named now as co-conservators. That way, if she passes away, the other people can step in immediately because they couldn't even allow days to go by. And the average conservatorship takes up to 6 months now, 8 months before it gets approved. There are emergency procedures that can be done, but it's a pain in the neck and gets extremely expensive. So, my advice, if you do have your child conserved, think about for the future. If you want to have both, if it's a husband and wife, husband, whatever, if there's two family members, two spouses, you want to have both spouse named as co. That's very, very important. Because you
So
never
once-
want a period.
So once they reach 18, that conservatorship, if it's in place, would kick in and you'd still be allowed to make
Yes,
medical
yeah,
decisions for
generally,
them.
we recommend doing it when they turn 17 and a half.
Okay.
And
I
the
wanted
court-
to-
Because the court actually appoints an attorney on their behalf. I'm sorry, Sandra, I know I went over.
Oh, I wanted to say that if you can afford to pay for conservatorship, there's a self-help clinic. You do most of the work and they review your paperwork. And like Jonathan says, it takes a long time. but it,
Oh,
lot
that's,
of
you're
us
right,
have-
that's through,
so I
Jewish
put it in the
organization.
chat. I put it in the chat if you guys, I just wanted to mention that because I know a lot of my families are not able to afford to pay for a conservatorship. I mean, if you're gonna
Yeah,
save your money to pay for something, I would say save it for your special needs trust and try to do the conservatorship. And it's actually, they have a lot of,
yeah, what's it, because
it's a
Sandra, can you-
Betsedic, it's a
Ben
Betsedic.
Sedek, that's it, Ben Sedek in Los Angeles.
Yeah, I want to, maybe I'll share my,
Jonathan, Jonathan, real
Yes,
quick, when you do a conservatorship, do you have to send letters to every member of the family to make sure?
yes, yes. They
So
have
how
to be
do you-
given an opportunity to object.
Right, but how many? Like, how far do you have to go? Like every cousin,
No, generally you go back 2 levels.
to what?
You go back 2 levels. I stop at uncles, at aunts and uncles,
Okay, so you just do siblings?
siblings, and go to aunts and uncles.
Grandparents
Grandparents,
too?
aunts, yes, absolutely.
So grandparents, aunts, uncles,
Yep,
and siblings. And if the grandparents are like in their 80s and 90s, would you still include them?
doesn't matter,
Okay,
doesn't matter. It's
What if
all
they're
about
dementia?
notice. It's all about notice. Doesn't matter. You have to
Okay.
notice them.
So just
And
making
it's
it
just, they
legally.
get something in the mail.
Yeah.
That's all.
so just aunts, uncles, siblings, and grandparents.
Yep,
Okay,
yep.
not
yep.
nieces and nephews and everything.
No,
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 okay,
no. Generally I don't. You can, the court wants to see that there's enough people getting notice,
okay,
okay? That's what it's about. It's about enough people getting notice. I generally over notice because I'd rather have extra people notified than not.
okay.
The
Even
court
though
likes
you
it
know,
that way.
even though you know they won't object, there's no way they're gonna object, you know it.
Exactly.
Okay.
It's just a piece of paper that it's a piece of paper. That's all it is. They're getting in an envelope a piece of what you're filing. That's all.
you also have to notify the regional center.
Yes,
about if they're
if they're a regional center candidate, yes, and if you're Down syndrome, it would be clients of regional center.
And what about estranged family? Aunts, uncles, grandparents, if you had anybody
Doesn't
estranged, you
matter.
still notify
Doesn't
them?
matter. Yeah, if you don't know the address, you let the court know that they exist and you say there's no known address. And you've made a reasonable attempt to contact them.
Last month, we had a presentation on conservatorship. I know a lot of them probably missed that. And if you send me an email, I'll send you the information that we have regarding that.
Yeah, Betsedic, by the way, is a fantastic organization. Fantastic. They've been doing self-help clinic for conservatorships for years. They have it down to a science. They'll provide you forms. They'll provide you, sample answers, everything. It's real easy. Know that in fees alone, it's going to be about $1,500-1,600. All right.
When you
through-
have
through them?
when you have with Betsedic, if you have your,
If you're low enough
Some-
income, you can get a fee waiver, but you have to apply for a fee waiver.
when your son, daughter are 18 and they're receiving Medi-Cal, I guess, and SSI, they waive the fee. So it's actually really, you pay nothing.
Well,
So-
the conservatorship, you still have to apply for a fee waiver.
Because they, like I said, they help you. And so
Yeah,
This is
yeah,
a
and they have
website.
that form. They have that form.
the forms are online and you can see the
Yeah.
forms are English and Spanish. So, and then they'll just help you through the process,
Yep.
You have to fill out all the forms yourself. And, but anyway, I just wanted to share that because.
Yeah, I can't recommend them enough. I can't recommend them enough. In fact, some of their volunteers are more knowledgeable than a lot of attorneys I know. That's how good they are. 'Cause that's what they're known for. All right, any other questions before I let everybody release you? All right, folks.
Thank you.
Enjoy the rest of
Thank
your
you so much.
Saturday. Sandra, I will send
Very
you the paper.
Very
Thank you so
informative
much.
and simple language. Thank you.
Yeah.
My
Thank you,
pleasure.
Jonathan. Thank you
Thanks
for
so much.
spending
Thank
your,
you.
thank you for spending your morning with us, and enjoy the rest of your weekend. Jonathan, thank you so much also for volunteering your time to DSALA. We really appreciate it. Have a
My
great
pleasure. You
day.
guys do great work. Take
Thanks a
care,
lot.
Thank you.
everybody.
Have a great day. Thank you.
Bye-bye.
Bye-bye.
Bye, guys.
Thank you.